Good evening, all. I'm going to, if I may, call us to order. Thank you. It's a great privilege and honor for me once again to be invited by the Shipping Law Centre to chair one of its seminars. I was just remarking to Sean on my left that one of the great benefits of now being on the bench is that I'm usually invited in an event like this to chair so that A, I don't have to write a paper. B, I don't have to have, and indeed, on one view, I'm not even allowed to have any views about anything other than those I might have expressed in a judgment. On this occasion, however, I am more nervous than usual because it feels a little like coming before a panel and room full of experts to have my homework marked a second time, having already had it marked once by the Court of Appeal, in which they found that I had arrived at the correct answer for entirely the wrong reasons. Or perhaps I should say for a third time, because as I'm sure most of you will know, the Supreme Court heard argument in the Flaminia a month ago, and we await judgment. So who knows where they will reach by way of landing. Claiming, as some of you know, not really to be by original practice expertise a true Admiralty lawyer. As Admiralty judge, it's been a particular pleasure that a few of the interesting cases that I've had to deal with in the last few years have been on the tonnage convention, whose history goes back more or less in this jurisdiction 300 years or so. Adrian reminded us in an email in the build-up that the first English legislation was 1733, so we are pretty much coming up to the 300th anniversary of there being statutory foundation for a principle of limiting liability in some form or other, directly or indirectly related to relating to the value of the ship rather than being exposed without limit to the full gamut of liabilities that might have arisen. I'm going to adopt the modern style of chair and not spend time further introducing the very distinguished panelists to my left, none of whom I suspect really requires introduction in any event, all of whom will be available online in terms of biographies and background so that you know who they are. But we have, courtesy of the Shipping Law Centre, the usual collection of most distinguished and experienced practitioners to tell me where I went wrong or possibly went right, or and more importantly, it may be to draw threads together as to where the law may now be or may now be going. And so without any further ado from me, I'm going to hand over to Sean, who will be speaking first. Thank you very much.
Thank you very much. So I'm doing the warm-up act. I'm going to cover very briefly an introduction to the Limitation Convention and then cover really three topics. First, jurisdiction, then the long vexed question of who can limit, and finally the currently fashionable issue about what types of claims are subject to limitation. The Limitation Convention, or the LLMC 1976, if you haven't come across it before, it's essentially about matching the extent of exposure to the size of the vessel. And the explicit reason for it is fairly obvious. It's to encourage investment in shipping and ship owners. The way it works is that the ship owner can limit, by reference to a fund, to a total limitation figure for certain types of claims. And the way in which the figure is calculated is set out in the convention, and you'll be aware that there's been some increases over the years in 1996 and 2016 in England, which now set the levels a bit higher, but it's all done by reference effectively to tonnage. There've been a spate of claims and actions in recent years in the English Admiralty Court. I put on the screen, I hope you can see behind me, three of the most well-known ones. The Ever Given, of course, in the Suez Canal, the Maersk Honam in the Arabian Sea, and then the Express Pearl off Sri Lanka. All of those you will quickly recognise have nothing really to do with England, nothing to do with English or UK waters, not UK flagged. But the English court's always taken a relatively relaxed approach to jurisdiction in the context of these limitation claims. So limitation can be raised in two different ways. It can be raised as a specific defence to a specific claim brought by an individual claimant, or if you've got or suspect you're going to have a multitude of claims, you can start a limitation action in the Admiralty Court seeking a limitation decree, which would then be valid or should be valid against all claims. Now, that latter possibility is not dealt with expressly as to how that or where that should be brought in the convention. And in England, there are a number of principles that make England relatively friendly as a jurisdiction for such limitation actions. The first is that there's no requirement that that limitation issues and the underlying liability issues are dealt with at the same time in the same place. That's often what happens in practice because it's convenient for cargo claimants to have all the issues dealt in the same place. But conceptually, there's no need for that. Another important point in England is that the right to limit is treated as a procedural rather than a substantive matter. And what that means in practice is that it doesn't affect the operation of English law as the law determining whether or not you can limit and the level at which you can limit. What law happens to govern the substantive claim, which again makes England an attractive place to litigate these issues. Now, you might think at first sight, when I put up on the screen Article 11.1 of the Convention, that does suggest a particular approach to where claims should be brought. It says any person alleged to be liable may constitute a fund, set up a fund, in any state party in which legal proceedings are instituted in respect of claims subject to limitation. And you might think reading that, well, doesn't that mean that you have to bring them in a place where legal proceedings have been instituted? But in the Western region, it was found that wasn't a jurisdictional requirement. And in practice, therefore, the only jurisdictional requirement in the English court is that you're able to serve a named defendant, whether in the UK or by following the rules for service out. The respondents to the limitation action can seek a stay on forum non-convenience grounds, but that's pretty tricky in England because, as I said before, the question would be whether it's the appropriate forum for the limitation claim, not necessarily for the underlying substantive issues. And the general approach is that the courts take the view that a ship owner has the right to choose the forum in which to set up his limitation fund. That's dealt with in the Volvox Hollandia and in the superbly named Big Kahuna. And that second case also establishes that just because one jurisdiction has a different limit than another jurisdiction, that won't necessarily mean that it becomes an inappropriate forum or that England becomes an inappropriate forum. The question on jurisdiction that clients always ask is the one in the final bullet point there. What's the practical effect of having an English limitation decree if the substantive claim is being brought elsewhere? And I'm afraid the brave answer of the English lawyer is it depends. But it may be that Adrian can help us with some more practical tips on that in due course. He promises he will. I go on then for jurisdiction to who can limit. The convention uses the word ship owner, but it then gives a very wide definition of that word, a wider definition than we might instinctively opt for. It means owner, charterer, manager, and operator of a seagoing ship. At one stage, it was thought that a time charterer would only be entitled to limit if acting in the capacity of an owner. So if it were the time charterer were issuing its own bills of lading or the like. But it's now settled that charterer in the convention means charterer. So time charterers can simply limit their liability even against, for example, the ship owner under a charter party. And indeed, it's recently been confirmed that even a slot charterer, so someone who's simply buying a regular slot on a container ship, even a slot charterer can limit as if a ship owner, in the same way as a ship owner. But it's not a complete free-for-all, because the Stemmer Barge number 2 made clear that just providing personnel to operate machinery on a dumb barge, that doesn't make you an operator. So it's not that everything comes in, but the definition's now clearly very wide. The question of who can limit having been, for the moment at least, largely settled, attention has shifted to what claims are subject to limitation. And here, Article 2 is the key provision. I'm not going to read it out to you. I know it's quite small on the screen, but can I pick out 3 introductory points? The first is that if you can see the initial words, it's the following claims, whatever the basis of liability may be. So it doesn't matter whether the claims are being brought in contract, in tort, or by reference to some other analysis in some other jurisdiction. The question is whether the claims fulfill the description or fit the description in the following subparagraphs. Second point is that note that Article 2(1)(d), wreck removal, doesn't apply in England. There was a derogation in that respect. And third introductory point, the limitation convention doesn't apply generally to oil pollution damage, which is caused by oil being carried as a cargo. And the reason is as I'm sure you know, there's a different convention that deals with that subject matter. But the convention can apply to bunker pollution. That then brings me on to the MSC Flaminia, which is a case obviously dealing very much with the question of which claims can be limited. She's a container ship. There was an explosion in the cargo hold resulting in a fire, which caused a considerable damage to both the ship and the cargo. And sadly, 3 of the crew lost their lives. The cause was auto-polymerization of DVB. There was a build-up of pressure in the tank containers which were being carried in the hold, and some of the DVB, some of the gas vented and was ignited, causing an explosion. As a result, the vessel had to go to a port of refuge and carry out very substantial repairs. Conti, the owner, sued the charterer MSC, time charterer MSC, in arbitration, and was awarded damages of something of the order of $200 million. MSC responded by bringing a limitation claim in England. And to get the first point out the way, it was decided at an early stage that Conti didn't have an Article 4 defence. That was dealt with summarily because it had already been decided in the arbitration that MSC was not even negligent. So it couldn't have an Article 4 defence. It couldn't break limits. So the question then was, what are the limits, or rather, which of the claims are subject to limits? The claims included claims for the costs of payments to public authorities in order to go for the vessel to be able to go to the port of refuge, costs of discharge and then salvaging or destroying the cargo, and costs of disposing of contaminated firefighting water and other waste materials, and also the costs of repairing the ship. Now, MSC's position was that all of those claims were subject to limitation, and they relied first on Article 2(1)(a). And I've repeated the text of that at the top of that slide. The key words for present purposes are claims in respect of damage to property and consequential loss resulting therefrom. Now, the starting point for the analysis is that everybody agreed that there's no right to limit in a claim for damage to the vessel whose tonnage is being used to calculate the limitation amount. Put more simply, property in Article 2(1)(a) doesn't include the ship herself, and that's CMA, CGM, and Classica. That was the principle that MSC was trying to find a way around. It was common ground that the auto-polymerization and the explosion constituted loss of or damage to cargo, i.e. the DVB, and that cargo, the DVB, was property for the purposes of Article 2(1)(a). So MSC's original argument was that all of the claims were within Article 2(1)(a), because they were all caused by the loss or damage to the cargo, i.e. the explosion. And therefore all the claims, they said, were for consequential loss resulting from damage to property. They were all consequences of the damage to property, the explosion. That then came before this gentleman. Does anyone recognise this man?
Somebody should buy him a new tie.
Yes. That's rather alarming, isn't it? He looks exactly the same. It wasn't just taken minutes ago, I promise. I got this off the internet. Yes, the learned Admiralty judge rejected MSC's argument and held that Conti's claim was in respect of damage to the ship, not in respect of damage to the cargo. And it's important to see how this is a question of analysis, not just a factual question, because what the judgment decides that the fact that ship damage results from cargo damage doesn't turn a claim for damage to the ship into a claim for damage to cargo. Put another way, Article 2.1 is about claim characterization, not about factual causation. It's about the nature of the expense and why it was incurred, not about, if you like, the chronology. MSC also relied on Article 2.1e and F, and in those regards, the learned judge held that all of the costs were necessary, in fact necessary, in order to repair the ship. And therefore, the claim characterization was that there was one single claim for damage to the ship, which, for the reasons I've explained, couldn't be limited. It was held that it was irrelevant that some of those costs, for example, the removal of the firefighting water, might have been incurred even if the ship hadn't been repaired, even if she'd been being scrapped. It was said that was just speculation, given what did happen, which was that the ship was repaired, and that was why the water was removed. It was also decided that the cost of handling the cargo, as between the owner and the charterer, was not cargo removal for the purpose of Article 2.1e, but just discharge, because it's between owner and charterer. It didn't matter that it was happening at a different port. And it was decided that Article 2.1f only applies if it's a cost incurred for the sole purpose of mitigating loss that could be limited. So note those words, the sole purpose. That then went to the Court of Appeal, and it's fair to say, as Sanju's already indicated, that they arrived at the same final result, that Conti's claims weren't subject to limitation, but for a rather different reason. And in particular, Lord Justice Mayles focused very much on the fact that Article 9 provided a single limit, a single fund, if you like, for all claims against ship owners. And he suggested that that resulted in an absurdity, because he said if a charter is entitled to limit its liability for a claim made by an owner to recover losses which the owner itself has suffered, as distinct from the owner passing on to the charterer a liability incurred to a third party, that would mean that the owner's own claim might have to be paid out of a fund constituted by the owner itself. We said, can't be right, the owner would be paying his own claim. And on that basis, the Court of Appeal held that Article 2 must be interpreted as effectively having an implied exclusion in respect of any claims by an owner against a charterer for losses suffered by the owner itself. So as opposed to cargo claims or whatever else it might be, originating with a third party. Now, that was sufficient to resolve the appeal, because all of Conti's claims were claims they had suffered themselves. But for what it's worth, the Court of Appeal didn't agree with the learned Admiralty judge on the single claim analysis. They said that each specific type of claim, the question was whether each specific type of claim falls within Article 2.1. And they also took a slightly different approach to Articles 2.1e and f. So on 2.1e, they didn't have a difficulty with the idea that removing cargo would be removing cargo even if it was done by the owner or the charterer. And on 2.1f, they said that it had to be the mitigating measure had to be the main or dominant purpose of the measure. The fact of mitigation had to be the main or dominant purpose, as opposed to the sole purpose. So slightly different approach there. This is now all with the Supreme Court. The oral argument was heard back in February for 2 days, and we're, as Andrew says, we're waiting for the decision. So at this stage, it's the High Wire Act, as I speculate what they might be minded to do, with the only hope of a soft landing and the netting being that probably by the time you read the decision, you'll have forgotten what I predicted. But for what it's worth, my sense from having read the arguments is that they may be minded to move away from, or maybe minded to focus very much on the words of the convention, and if anything, to lean towards having more claims being potentially limited, and therefore move away from Lord Justice Males's implied exclusion. Some of the bits of the argument that I saw suggested that they were puzzled as to where that exclusion was to be found in the wordings of Article 2. And the truth is, it's very heavily dependent, as I said, on this supposed absurdity of the ship owner paying his own claims. And there's actually another solution which might be thought to be neater to that, which is that you could say that the ship owner, if the charterer's breach has caused the ship owner to have to put up a fund, then that claim for the cost of putting up the fund is not subject to any limitation, and therefore the owner is not going to end up paying his own claim. So it may be that that's an easier way of resolving the problem. Again, just to complete the predictions, it seems perhaps unlikely that they will adopt the single claim analysis. Sorry, Sir Andrew, but mostly because Conti don't seem to have been arguing it quite that same way when they got to the Supreme Court. They seem to have taken a different approach. They may well agree with the Court of Appeal about the discharge of contaminated cargo, because there seems to be a movement in that direction. And they may well adopt the dominant purpose test for Article 2.1f, because there is an evidential difficulty with identifying a sole purpose for any particular measure. Now, to my mind, the most difficult area is probably this last one about consequential loss and overlapping effective causes, but I'm conscious that I've run out of time. So I'm going to leave that, and if anybody's interested in that question, we can come back to it at the end.
Sean, thank you very much. I think I should perhaps have said in my introductory remarks that I was going to adopt again what has typically been the pattern for these seminars, and that is to invite questions once we've heard from all three speakers to make sure we give each of them enough time to develop their thoughts. So we're going to move straight on to Ravi, and then we'll take questions to any or all of the speakers all together at the end. Thank you. So yes, Ravi.
Thank you very much. Thank you everyone for coming. It's a real pleasure to be back at the LSLC with you all this evening. I'm very grateful that Sean has covered the Flaminia so comprehensively. And for the most part, I'm going to be looking at some different cases in my presentation. This, by way of overview, is what I'm going to speak about. And let's move straight on to the first heading. Pollution claims, wreck removal claims. Although similar considerations do, of course, apply, I'm going to focus for my presentation on wreck removal. Pollution has been dealt with already in the context of the Flaminia. Now, the starting point is Article 2.1d of the Limitation Convention, which, if anyone is unfamiliar with, I'll just put up on the screen there. This deals with, as it says, claims in respect of raising, removal, destruction, or rendering harmless of a ship which is sunk, wrecked, stranded, or abandoned, including anything that is or has been on board such ship. As Sean mentioned, it is possible for contracting states to disapply Article 2.1d. This is expressly provided for in Article 18. It's also possible to exclude 2.1e, which the United Kingdom hasn't done, but has excluded 2.1d. Now, 2.1a we've already looked at, but just bear in mind that we need to be thinking about this in the context of wreck removal as well. Well, why have I flagged that? The answer is quite straightforward. I think the eagle-eyed amongst you would have spotted that on just the language of 21A and 21D, prima facie, some claims could fall within both the language of 21A and 21D. Now hold on to that thought, because of course, as I just mentioned, some jurisdictions have exercised their right to contract out of 21D, no right to limit in respect of rec removal. So actually, it's not just semantics. It might be a really practically important question as to whether a claim falls properly within A or D. There are three cases we need to look at on this point. Twit Navigation, which is a case from Norway. Star Centurion, collision with Antia, and Goliath, a collision with Berth Tugs. There is one point which I think the Admiralty judge will be able to speak about today without any reservation, and that is whether that case has been appropriately named. The purists among you will immediately take the view that coming together with Berth Tugs is a collision, not an elision. Back in the day when I grew up, a elision had to be with an immovable object, like a bridge that the Dali alighted with. So let's hold that thought, and perhaps we can ask Sir Andrew for his views in due course. But let's get back. Twit Navigation, this concerned the right to limit. There are sections there of the Norwegian Maritime Code. Section 172 simply put into domestic legislation the limitation convention regime. 172A was a separate national scheme providing for certain higher limits, which again is fine. The convention only sets minimum obligations. It's okay for the Norwegian Maritime Code to provide for some different provisions if necessary in certain circumstances, especially where there's a right to contract out. So in Norway, there has been the Article 2.1d reservation, but for some purposes at least, it's replaced in Article 172A with a slightly different national regime, which provides for liability, but with a higher limit. That's fine. Because, of course, under the convention, states are entitled to have no limitation at all for those sorts of claims. If they want to, it's an opt-out. So nothing untoward there. Claims were by the Norwegian state against Twit Navigation for loss of a Navy frigate. That was agreed, that could be limited, but also for the cost of raising and removing the wreck of the frigate. And that's where the dispute arose. Was that capable of limitation in a jurisdiction with no Article 2.1d because of the opt-out? There we go. That just explains the two-track system I was just telling you about under the two sections, 172 and 172A. Now, what did the court in Norway decide? Rejected the submission that was made that all wreck removal claims, even one which could fall within the scope of Article 2.1a, must be subsumed within Article 2.1d. Interesting. What the court thought was that Article 2.1d was likely to be directed towards wreck removal claims primarily brought by public authorities. And those obviously gave rise to considerations of the environment, pollution, and those sorts of things. Interestingly, the point was made that the 1957 convention, in its equivalent provision, actually referred to statutory duty in terms. And although that was not carried forward in terms in the 1976 wording, the view was that there was no evidence of a fundamental desire to change the basis of limitation or contracting out, which was equally possible in 1957. Such considerations were not engaged here. This was not a claim by a public authority, and so there would be a right to limit the Norwegian state's claim pursuant to Article 2.1a. Now, that is the position from a civil law jurisdiction. We're now going to move to the common law world, starting with the Hong Kong Court of Final Appeal. Main judgment was given by a very distinguished non-permanent judge, former Chief Justice of the Federal Court of Australia and a former Justice of the High Court of Australia, Mr. Justice Keane. This case arose out of a collision, January 2019, between Antia and Star Centurion. This was a case which happened in Indonesian waters, and for the reasons which Sean mentioned earlier on. The court in Hong Kong took jurisdiction, and there doesn't appear to have been any issue raised about it, even though the case nominally did not seem to have a geographic connection with Hong Kong, but there you are. What happened was the Indonesian authorities said to the owners of Star Centurion, you have to you have to remove the wreck. We're ordering you to do that. Here's the order we've issued. Fine. Owners of Star Centurion, of course, had to comply. You don't say no to orders of that kind. And they commenced these proceedings in Hong Kong, claiming damages and indemnification. Now, the owners of the Antia, no issue about responsibility. They said, okay, fine. But then they brought proceedings against the owners and all other interested persons, so seeking a general decree to limit liability and establish their fund. And you can see on the figures, it did make a difference because the claim was likely to exceed limitation when all the elements were brought into account. Owners of Star Centurion said, no, we want a declaration from the court that you can't limit in relation to wreck removal because of 2(1)D, which in Hong Kong had also been disapplied. And the Hong Kong, it went all the way to the Court of Final Appeal, but the judges at each stage, so first instance, Mr. Justice Anthony Chan, and also the Court of Appeal reached the same conclusion. And they said, well, look, the effect of the specific has to be distinguished from the effect of the general. Article 2(1)D deals with wreck removal specifically and in terms. And what that means is it removes from Article 2(1)A anything which could have wreck removal as its description, even if on the language that could otherwise be forced or even would naturally fit within 2(1)A. And so the consequence of that was where a state disapplies Article 2(1)D as they can under Article 18, no limitation of liability for any wreck removal claims. And the court made the point in its reasoning, well, the exclusion of the right to limit under 2(1)D, it wasn't just a removal of one of two bases upon which limitation might be achieved. It meant that all wreck removal claims were outside the limitation regime if a state had exercised its right to disapply. And also on the language, this is important, Article 2(1)D was not confined to claims by harbouring authorities. Twit navigation was of little persuasive force. Mr. Justice Keane didn't really like the reasoning in there, and it's a very detailed judgment, so you can go into it and see. Let's see where that takes us, though, because it takes us to the Goliath. I've already made the point about collision and elision. We can discuss that later. And really, as I've described on this slide, Mr. Justice Stewart in that case had the casting vote. Now, as a matter of deference, first instance judge sitting in the Federal Court of Australia, considering a former Chief Justice of that court's judgment in the Star Centurion, might have expected some deference to be shown. But no. And actually, this judgment really is worth a read. It's a real tour de force. The judge goes in some detail in analysing this particular point, looks at the Travo, looks at authority from all over the world, and basically tells us that the Norwegians got it right, which is actually pretty interesting. Article 2(1)D. He said, covered ground specifically related to claims arising from the exercise of a statutory right or power, and only those types of wreck removal claims, and not every claim which might be thought to give rise to wreck removal considerations, were outside limitation, where 2(1)D was disapplied. Star Centurion, he said, rested on the fundamental misconception, unless what is within Article 2(1)D is carved out of A and C, 2(1)D would have no work to do. And the answer to why that's a misconception is this: because the public authority wreck removal claims in 2(1)D don't fit anywhere else. If they're not in 2.1d, where are they? And that's why Article 2.1d does do work, even if the claims which otherwise fall within A or C are taken away. And you can see there what he thought about Mr. Justice Keen's approach. Now, as I understand it, the last I heard, there was an appeal being progressed in Australia in the Goliath. So this may not necessarily be the last word. But I posit the question, how would this be decided in England? Well, difficult to answer in the scope of the limited time I have today, but I do think Mr. Justice Stewart's reasoning is compelling. Actually, it's extremely impressive as a piece of work, this judgment. Everyone does seem to accept, I think this is fair, that wreck removal expenses which only fall within Article 2.1d and where an Article 18 disapplication is present are not limitable. That much, I think, is common ground. That where the problems arise is where the claim might fall within another article. And as I've said, I think that he got it right. But just a couple of practical points. So say claim or counterclaim against a salvor by ship owners who've signed an LOF with the salvor. They're claiming for salvorial negligence because wreck removal expenses have been incurred in respect of the vessel the salvor is supposed to salve. That's quite a common state of affairs for a salvor to have to fend off, actually, whether it actually results in a formal claim or not. There's some negotiation. Abstract level, well, I think there's something to be said for the point I've made there. Salvor's own claims can't be met with a limitation defence. So maybe in light of these sorts of considerations, the Goliath approach is correct. Pollution in distinction to wreck removal, I'm not going to say anything about because Sean has covered it so well. And actually, my points just raised some questions without positing any answers. I'll very briefly deal with res judicata and issue Estoppel. This is hot off the press, and it's interesting because Sean showed us a slide referring to Caltex and the thinking that limitation is procedural rather than substantive. Mrs. Justice Cockrell might cause us to question that now because in this case, she has found the opposite. She has made the point. Right to limit is substantive, not merely procedural, giving rise to res judicata by way of cause of action Estoppel. And as a general limitation decree binds the world, resultant res judicata can be relied upon by third parties to the limitation decree. There may well be an appeal on that case, I imagine, but that's hot off the presses and a very interesting case to read if anyone has time. I'm happy to pick up some other points I had about calculation of the fund and set off. Please ask in the Q&A or come and find me afterwards. But I'm going to pause there in the interest of time and hand over to Adrian now.
Ravi, thank you very much. Adrian has the rare distinction. I'm not sure he will even know that it is a rare distinction he has. Certainly, I think in this room, of being one of the few practicing lawyers still going strong from a London shipping practice background who will have met my wife as a lawyer before he might ever have met me, because she was an article clerk in Richards Butler when Adrian was still Richards Butler before Moore Fisher Brown was more than a twinkle in somebody or other's eye. But thank you very much for heading to us from Oslo, Adrian, and we look forward to your perspective on either these or other related issues from the point of view these days of a club and the insurance industry. Thank you.
It's my pleasure. I'm just going to get to the end of Ravi's presentation at some point because we're still going strong yet.
Oh, yeah, there's plenty
of there's plenty of reading material here.
Plenty more.
Plenty more where that came from. Well, I'm going to take you away from the English court and I'm going to give you a whistle-stop tour of limitation cases around the world. And there's a number of people in this audience who know some of these cases far better than me. That's the worrying thing I've got. I'm asked to look at it from an insurer's point of view. And in a way, that's an amorphous description because insurers are very different. And I was lucky that Ravi was going to talk about the Star Centurion. So I was going to use that as an illustration because that is the Star Centurion, looking very glossy, looking very nice. And that's what underwriters and MGAs like to see, because insurance is really income producing. It's a capital intensive business. And if you see a nice ship like that, you go, yeah, I'll take some premium. No problem, no risk. The hull insurer looks at it a different way. That's the Star Centurion again, hit after the Antea, which went right into it. And you think, well, can I salve it? Can I repair it? Do I have to pay out under a CTL? And then the next day you go, the LOF was a bad mistake. That's a problem now for P&I. That's wreck removal. And so when you see a wreck removal dispute between two ship owners, you're really seeing a dispute between two P&I clubs and their pool claims. So they're seeing a dispute between the reinsurance element of it. So it's a slightly farcical setup we have. But I thought I'd give you an example of where we go wrong and where things go a bit awry when you go around the world. So this is a case that occurred in South Africa. It's the vessel went into the berth, and the berth is just on the left-hand side. Let's say the port side as you enter through the channel. And by a combination of factors, it just simply crashed into one of the berth facilities and provoked a claim for about 30 million of damage, being mainly business interruption. And the question I suppose you look at is, well, whose insurance is going to pick that up? And you've got to go say, well, who's got the liability? Is it the hull insurer? And is it hull insurer limited to the value of the vessel? And then is there an excess liability on P&I? To which the answer is yes. So it's a P&I claim excess of hull when the hull picks up the liability risk. But the problem with the Julian, I'll go back to it because you're there in South Africa and you hit a South African terminal and you want to set up a limitation fund in South Africa. Whereas the claimant is going, but South Africa is a very low limitation area. Yeah. And for that reason, the claimant, who's South African, started proceedings in Germany and then arrested the ship in Hong Kong. And the argument in South Africa was, can we force the claim to be brought in South Africa where the ship owner wants to set up a limitation fund? And the South African court said no. The claimant can choose to litigate where he wants. Now, we would have appealed that, but it was compromised before we ever had the chance. The Milano Bridge, on the other hand, was a damage to another terminal, and this time was in South Korea. But the Korean operators of the terminal wanted a higher limitation than was available in Korea. So they arrested the vessel in Singapore. And Singapore said there's no particular reason why the ship owner shouldn't be allowed to bring his limitation action in Korea. And the fact that it's a lower limit is no great juridical advantage and should not be a reason for keeping the case in Singapore. So you have forum shopping and people choose where they want to be sued. And there's no great logic why the owner of the ship should have the right to select where he establishes his fund. He's not the person at fault. He's not the person, he's the one who's got a cap on his liability. And then you come to the A Symphony and the CE Justice, again, two P&I clubs. This was a vessel that was off China. It was hit very similar to events in the North Sea in slightly foggy conditions. And an immediate attempt was made to issue in rem proceedings in Singapore. The owner of the Sea Justice, however, established a limitation fund in China, which was a lower limit. the owner of the A Symphony tried to sue the owner of the Sea Justice in the Marshall Islands, which is where he was registered. And that was stayed on the basis of forum non-convenience. The owners of the Sea Justice tried to get an anti-suit injunction preventing anyone suing him other than in China. And the Chinese court said, no, you don't have an anti-suit injunction. A limitation fund doesn't have the power to compel everybody to come to the one fund. So as the ship came into Singapore waters, the Sea Justice, under its new ownership, was arrested. Yet the Singapore court said, we don't have the same concept of permitting security for a foreign judgment in China. So we're going to let the security go. So you have this varied selection of answers that come out of different parts of the world. And you'd probably got a different result out of Australia. And then we have one of our favorite cases, the Ever Given. The incident occurred in Suez. We have a UK limitation fund administered by Sir Andrew here. And of course, there are a number of, there's no cargo claims here, as you can see. The big claims are general average and salvage, outside limitation. So why a limitation fund? That's because a number of owners paid from passing through Suez. And the claims there totaled some 50 million. Some various fishermen's claims were brought, totaling about 50 million. And the owners, through their club, settled some of the Suez Canal Authority's claims and claimed as a subrogated creditor in its own fund. That takes it above the 100 million limitation. But the claims by the other ships are governed by Egyptian law. Luckily, they all settled. But the question that might still arise is whether a claim that is brought in Egypt and is settled, can the owner claim a subrogated right against his own fund? And that might become a live issue. And then you've got another case in Singapore where COSCO managed to damage a terminal in Indonesia and obtained an anti-suit injunction on the basis that the terminal had or whilst the action and the tort occurred in Indonesia, they were also the receivers of the cargo. So under the terms of the bills of lading, they had a Singapore arbitration clause. So that the case was dragged away from the venue where the incident occurred and taken back to Singapore. I just mentioned the Maersk clause, and because that's the one of the few times we've persuaded the Greek courts to apply the limitation convention correctly. But there's another little quirk, which is in France, of course, they still believe that French law applies to when the incident occurs within their jurisdiction. And for that reason, any attempt to require a pay to be paid provision to be inserted will not survive. And so they want to have a right to bring a direct action against the insurer, which is something we don't like very much. Prestige is another case that always makes us qualm. And then we look at the Dutch, because the Dutch have two funds. And they had this interesting case where there was a collision at the anchorage in very bad weather. The crew were removed from the vessel. It then went and hit two more wind farms on the way. And the question then became, was it a single incident or was it three incidents? And if it was three incidents, in theory, you would have three funds. The Dutch court at first instance said it's a single incident, it's all the same continuing event. And that was going to be appealed, but has now settled. So we will never know. Another case that occurred off Indonesia. Dutch funds for both wreck removal and property funds were set up, but the Thorco cloud interests decided to go for a direct action against the Norwegian insurer, which may just happen to be Gard, but it went up and down in the Supreme Court in Norway, it went up and down in the Supreme Court in the Netherlands, and again was eventually settled. But it again illustrates you do not always have the right as an owner to direct where the fund is and where the action is brought. And it just reminds me of the Baltic Ace and the Corvus J, which was the car carrier that sank. And the Baltic Ace arranged to be sued in the Isle of Man, which was its place of venue. And the Dutch authorities were most upset that they had to go against a relatively small single fund rather than two funds in the Netherlands. And I'm sure Mr. Eddings might remember that. And I can't leave you without giving you a quick mention of the Dali, which is our favourite case. The extent of the claims in the Dali are significant. You've got various physical damage, economic loss, cargo damage. The main sort of immediate response claims have been settled. But the issues come to, can you limit liability? Because the claims exceed about 2 billion and the limitation fund is 43 million. Now, the interesting thing about where you fight is that some claims you can defend easily. And in the States, they're not as easy to defend as others. Whereas the 76 Convention, we've now got unified interpretations that it has to be a willful default of the owner to break limit effectively. And so we'll see what happens with the limitation of liability. You might get a gross negligence claim. And will the economic loss claims be shut out? That's the current law in the States, but that's bound to be tested. And I just wonder where limitation will end up, because we do have the US deciding to change the rules after the event. We've got the Chinese who decided that the fines that they applied to the Sea Justice and the A Symphony would total 97 million. And that wiped out the value of both of the funds. So the Chinese government took the money of all the creditors. And there comes a time when you go, well, should we be applying international comity between nations when the rules have changed? And there's one thing I'm saying about the Flaminia. The waste regulations now make it very, very difficult to know what a ship owner can do, because he has to dispose of not only the firefighting water, but the cargo, which is damaged. And if he does it at the first place, the first port of refuge, it's probably limitable. If he doesn't anywhere else, he's got to comply with Bâle's Convention or the EU waste regulation. And I'll just do a last pitch for CMI, which is trying to harmonise the maritime treaties in the current climate. And I wish them luck. And that is me. I will just give you what I think is good, bad, and ugly. Because I think the advantage is that if you have the same convention anywhere in the world, it should be the same outcome. The bad thing is you have people trying to look for jurisdictions which are more favorable, and wreck removal is an inconsistency. And I don't like direct actions against insurers in any way. And that's it for me.
Adrian, thank you very much. May I firstly invite us all to thank our speakers initially in the traditional way for their thoughts so far. And as we start the roving mic process, and you're thinking of who wants to ask a first question, as I sometimes do, I'm going to exercise my chairman's prerogative and throw a question with at least one or two of my panelists. It's for Sean initially, although there's a link in the subject matter, some of what Adrian was mentioning. It does the, as you put it, or not quite this phrase, I think, but does the relative irrelevance or unviability in this jurisdiction of forum non-conveniens type arguments in a limitation action somewhat go hand in hand with the view that, at least hitherto, we have taken, that the procedural right to limit is not similar to something like a right to arbitrate that we're going to police by an anti-suit injunction. Because conversely, if we were to take that view, which has been taken in Singapore, for example, one might think it's quite an extreme example of extraterritorial police action where we were both anti-suiting people from suing elsewhere and also saying, but don't talk to me about forum non-conveniens. That's not really a factor here.
No, I think that must be right, that the two things do seem to go together, that the English court's approach is very much, we will have your limitation action, we will resolve your limitation action, but we won't stop you, as Adrian's pointed out, we won't stop you suing on the substantive issues somewhere else, and then bringing, the idea is, whether this is how it works, opinions may differ, but the idea is you bring your judgment or your award to the English fund and you get paid out in whatever it is, cents on the dollar or whatever it may be, on that from that fund. It's not, you do see in practice some of these claims that Sanju's dealing with in the Admiralty Court, they are all everything's being dealt with in the same place. All the cargo claimants happen to be happy, even if they had arbitration clauses to deal with the questions in England. But there's nothing to stop them going to wherever it is they may be and coming back with their judgments or their awards. The bit that is then tricky is, what if they are doing, or what if they're seeking to do that in a jurisdiction that doesn't respect the English decree? And what will be interesting is whether in any of those cases we start to see the English court being asked to grant an anti-suit on the basis that it's not that the matter can't be resolved in the other jurisdiction, it's that it shouldn't be allowed to, what's the right word, dodge or evade the protection, the inter pares protection of the decree and the fund. We'll see.
Thank you. Questions from the room, if any? Who would like to go first? We've stunned the very erudite room into silence. I have another one up my sleeve if you really need me to go again. For Ravi, if this is even a meaningful way of thinking about things, are the decision and reasoning in the Goliath, which I will not claim to have read, are they more congruent with my way of looking at Article 2 at first instance in the Flaminia, more congruent with how it struck the Court of Appeal, or not really related much to either of them? I mean, obviously, we were not directly dealing with the same point, but one of the things, at least I said, whether rightly or wrongly, but which seemed to me to be correct in principle, was that it would be wrong in the context of our version of the tonnage limitation, which, if you like, notionally doesn't have Article 2.1d in it because we've disavowed it. It would be wrong for that reason to construe the other subparagraphs differently to how they would properly be construed if you had the full version. So in that sense, the correct meaning and effect of Article 2.1d query on my approach to things as a matter of claim characterization, not factual causation, as Sean put it, would be a possibly relevant way of looking at things. Is that sort of resonant with how it was being looked at in the Goliath, or is it just different?
I'd love to answer differently, but I'm afraid I can't. I think it's different For a number of reasons. Firstly, in the Goliath, only Article 2(1)(d) was relevant. There was no consideration other than 2(1)(a). Obviously, there was no consideration of the other provisions. Second, Australia has exercised the right to disapply 2(1)(e). So neither 2(1)(d) nor 2(1)(e) apply. And therefore, by combination of those two things, I think it's difficult to distill a view either way as to how Mr. Justice Stewart would have approached the particular question which you have raised. But as I've said, I do think this is going to go to the court, an appeal court. So it would be the Court of Appeal, the Supreme Court of Western Australia, I think, or wherever they go from the federal court first instance to appeal. I'm not an expert on Australian procedure, but I don't think we've heard the last of this. This is going to at least have one more outing.
Very good. Thank you. Yes.
Hi, thank you for the fascinating talks. The question is rather commercial rather than legal, and it is to Son of Sullivan KC and to Adrian Moylan, and what is anticipated to be the impact of the MSC Flaminia in terms of charterers' rights to limit in renegotiating the contracts, and what is the anticipation for, you know, how they're going to be dealing in managing the risk. Thank you.
Let me go first, because charterers have the ability to take out significant insurance cover. And in the Ocean Victory, for example, the claim was about 175 million. In the Flaminia, it's 200 million. And there's no hint that charterers are unable to obtain that sort of cover. It's a very high market cover and it's a high risk, but it can be achieved and it can be obtained.
What my sense is that they may be moving towards allowing more claims to be limited, whether that be by owners or by charterers. So that might suggest a slightly different answer to Adrian's answer, because I think Adrian's answer would suggest that one should be using insurance to solve the problem. Amazing, an insurer should think that, isn't it? But the slight sense, certainly of the bits of what I saw in the Supreme Court, suggests that the Supreme Court is in favour of the concept of limitation. There is certainly, if there ever was, there is no longer, and there's none certainly in Sir Andrew's judgment either. There's no sense that limitation is in some way a bad thing, like there used to be a view that exclusion clauses were something negative. It's very much perceived that limitation is, in inverted commas, a good thing, and obviously one has to strike the right balance so it operates appropriately. But I think overall the movement might be in favour of allowing claims to be limited, even by charterers, but certainly by ship owners.
I'm going to be very 21st century and take a question from an online attendee. They identify themselves as James Turner. There are a number of those.
I have a wild guess who it might be.
If it is that James Turner, then as Sean will know, that is to say James Turner of Quadrant Chambers, it will be a nice, difficult question.
But he writes the book on Admiralty practice, doesn't he?
And
we ought to get him to answer the question himself.
No, he wants you to answer it, Sean, very specifically.
Of course he does.
He says, picking up on your, and you can see it on screen with me, but I'll help the audience here. He says, picking up on your, he suggests entirely correct explanation of the way in which decisions on liability are intended to be then brought into and enforced against the fund. How he asks, if at all, can other claimants' interests be protected? And he posits this example. Suppose a contractual carrier or slot charterer, whom we now say can limit, possibly for commercial reasons, doesn't invoke a package limitation in a container case and thus finds higher liability judgments than if it had taken the point. What weapon, James asks, does the court or anyone else have to deal with what might then be thought an unprincipled disadvantaging of other claimants on the fund who are faced with a lower recovery? And while you're cogitating on that, because of course, you know, a fascinating aspect of limitation, I say this as having previously confessed it, not historically being a true Admiralty practitioner, being a dry shipping lawyer, if any kind of shipping lawyer. But one of the most fascinating things about tonnage limitation as a concept is its quasi-insolvency concept that nobody has actually gone bust as long as you've got the insurance cover or other means to put up the fund. And indeed, that's the entire point. It's there so that you create the fund to replace you as a group of corporates, it might be, who would be potentially liable and potentially threatened with non-existence, so you can carry on trading. But then once the fund is established, the administering of it is very much like being an insolvency judge. It's just that we've got a single defined fund rather than the insolvent estate generally, so we don't have to appoint liquidators. We just say, mostly for all the difficult questions, that's what the Admiralty Registrar is for. But there we are. So as to the particular question asked, how do you stop an insider potentially able to bring
putting its finger on
the quasi-subrogated claim into the fund that might have been set up by the owner, disadvantaging other claimants?
But if the party seeking the indemnity this is assuming the slot charterer has paid out to a cargo claimant and it's overpaid effectively, that's the logic, and it's now coming to the fund and saying, and that's, I'm assuming for this purpose, for the question's purpose, that this is not the slot charterer's own fund, it's someone else's fund, it's the ship owner's fund. They'd still have to then bring the claim against the fund. That claim could still be potentially, I'm not aware of this being something that's been decided, but I can't see why in principle that claim couldn't then be, what's the right way of expressing it, taxed down, adjusted to reflect its true value, and then the pro-ratering occurring once that's happened. Again, a lot of these kinds of questions, I'm not conscious of them ever really having to be decided, or if they have been decided, they're not being reported. But it doesn't seem to me impossible for that to be the right way of dealing with it. And as a matter of principle, that would seem the correct approach. It shouldn't, you shouldn't be in a position where you're bringing a claim against the fund and recovering more than you would if you were to be in a situation where you were seeking an normal indemnity. Normally, if you were seeking indemnity because of a breach by the charterer, say, and you were saying, well, I've paid out on this cargo claim, the charterer would say, well, you've overpaid on that cargo claim. You didn't invoke limitation. You should have done. That's a failure to mitigate. You only get what you'd have got if you hadn't failed to mitigate. Hard to see why the fund shouldn't work in the same way as that.
For that to be true, is that a solution? Is that, I'm not remembering well enough all the other provisions of the convention, is that applying some particular convention provision to find some effective relevant doctrine of causation or failure to mitigate the claim in some way so as to limit what can be put against the fund?
But isn't it
or is it a byproduct of simply saying that decision, whilst it may create a raised judicata between the parties to it in whatever forum they may have litigated to that result, does not bind the fund?
It doesn't bind the fund, and it doesn't. I think that's the answer. And I think I would see it as being an English law principle when English law comes to determine what sum of money is payable to this slot charterer in respect of the claim against whomever it may be, the ship owner who has set up the fund. It's their limitation, that claim that is ultimately subject to limitation, and that claim that would have to be brought, just as if there was a dispute about the quantum of any claim, that the court would have to resolve that. It's not I mean, it's an interesting question, but not one I know that there's a defined answer to. I guess that if there was, James would know what it was.
Yes, he wouldn't have asked the question.
He wouldn't have asked the question
if he had written that bit of the book with lots of authorities in the footnotes. Yes, very good. Are there any of that so far? Is the only and very interesting question online. Oh, there we go. The answer online is that James does not find this an easy question either. He suggests it is difficult, not least in terms of comity, for the English court in a limitation action to play the role of referee in the way suggested. That isn't.
He doesn't like my answer, but I mean, I understand the point he's making, but you might take the view that the same would be true when a judgment's made against anybody in another jurisdiction. It's, as Andrew says, it's res judicata between those two parties. But if you're seeking to bring it then as an indemnity against another party, it's open to that other party to say, well, you should have done something different. You should have raised this point or that point. We see those arguments all the time.
Yeah. And is it a case of playing worldwide referee as to where you are in some sense allowed to make your claim, or is it simply administering the fund that I've got in front of me as a quasi liquidator?
Seems to me the latter.
And having, in one form or other, to have rules that I can apply that do justice to the range of interests that are either actually or at least nominally in front of me. There's the entire world of prospective claimants.
Yeah.
Yeah. All right. Very interesting. Do we have any other questions in the room? Or does that feel like?
Can I ask a question about?
Yes.
Oh, is there someone else who put their hand up first? Sorry. I was going to ask a question about pollution claims, if no one else is asking anything, which is what view people take of claims for pollution, where, for example, because a lot of these claims we now see, vessels are causing, that there's a great deal of pollution caused by the incident. So take the Express Pearl, I think there was plastic pollution. Is that a limitable claim? I don't know if Ravi wants to have a go at that. I know he was going to answer that question. Is that a limitable claim?
I think it is, on the face of it. You could probably bring that within E, 21E, and depending upon the precise facts, it might also on the facts fall within 21D. Now, it may then require you to exercise some care as to where you seek to limit, because there are plenty of jurisdictions which disapply both of those provisions. There are some, such as the United Kingdom, which disapply D, but not E, which remains in force. And so I do think with the nature of some of these modern casualties and the sorts of claims which they give rise to, we may well see a greater degree of forum shopping for limitation than we previously have, just to make sure that you're in the right place.
And what about Sir Andrew's suggestion in the Flaminia, that if it was the beach that was damaged by the pollution, that would be A? Is there a problem with that? What do you reckon?
Wow.
There, you're allowed to have a view because you expressed it.
You all know what my view is, and by happy coincidence, you all know what James Turner's view is, or at least was, because I disagreed with it. I disagreed with what he had said in the book about that. Yeah, I don't know whether Ravi's going to be willing to offer a thought or not. No.
I agree with your judgment on this point.
How very diplomatic.
How wise.
Ravi, one final point, and it may show my failure quite to have picked up the gist, or it may be subtlety of one aspect of an example you gave. But going back to wreck removal,
yeah,
and at the risk of flogging a horse that the Court of Appeal tried to kill, the claim characterization view. If the claim characterization view of Article 2 is correct, is there then room for the view that the wreck removal provision is like the salvage provision? Are you making a claim for wreck removal? That is not the same thing as are you making a claim for expenses that you may have incurred that may have been caused directly or indirectly by a process of removing a wreck. And the link you made to salvage is I may have missed or misunderstood the point you were making about that. If and so far as a salvor is part of, amongst other things, a wreck removal effort, that doesn't change the character of their claim, which will still be for salvage and will still be dealt with separately.
Yes, no, I agree with all that. Where this is, I know from cases I've done, where this is causing the salvage community some concern is if the Hong Kong approach to wreck removal is correct, and if anything that looks like wreck removal is within Article 2.1d only and not otherwise limitable under 2.1a, it causes salvors a big problem because, especially under your typical no cure, no pay LOF, it's not at all an unusual occurrence that despite the salvor exercising best endeavors, they just can't achieve success and the casualty ends up as a wreck. Now, traditionally, if you ask any salvor, they have always taken comfort in the fact that, one, there's no limitation in respect of their own claim for salvage, but also if there was a counterclaim against the salvor in respect of the wreck removal, they would be entitled to limit. And one of the points I didn't have time to get onto was calculating the salvor's limitation fund. It does, in most cases, result in a relatively low limit. And that's the basis upon which salvors operate. It's part of their business model, knowing that they're doing all this speculative expenditure, waiting for a casualty. A quid pro quo is that they have certain defined and ultimately low limits of liability, or indeed no liability at all. Now, if the decision in Hong Kong is going to upset that delicate balance, I think there are some important industry conversations that need to take place.
And I'm going to draw us to a close by just offering this thought on the question that came from the floor as to the commercial considerations, not to offer a view of my own because I don't have one and wouldn't feel qualified to express one. But that is to say, the potential commercial importance or impact for charterers in particular of the Flaminia, ultimately depending on which way it goes in the Supreme Court. All I will say is that the time charterer in that case, as I understand it, regarded it as having sufficiently potentially important commercial consequences to pursue the appeal, although the case has settled. And as I understand it, there was a process that had to be gone through to satisfy the Supreme Court that they were not now seized of an entirely academic appeal. And whilst I will not pretend to know or to have a view or to wish to express any view about what the considerations are, I have the general understanding that MSC, which is the charter in that case, MSC have a view that it is indeed important enough to their business and the business of other container lines in particular, operating on a time chartered basis generally, to know whether A, the Court of Appeal and I are both correct as to the result in Flaminia, and B, if we are, which formally speaking would mean that the appeal fails again and the end result I arrived at is again upheld, but within that, knowing what the highest court makes of the difference of reasoning between my judgment of the Court of Appeal, am I right on that? Is the Court of Appeal right on that? Or is there a bit of a mix and match where some of what I said is to be preferred and some of what the Court of Appeal is preferred, is apparently regarded as important enough to be worth pursuing the appeal, even though the case as a whole in Flaminia has, as I understand it, completely settled. Thank you very much to everyone for your attendance, for your engagement with our speakers.